Good morning, the dignitaries on the dais and off the dais, my lawyer friends, former judges, and I call the lawyers, I have a distinct name for lawyers. They are crusaders for justice, not merely lawyers. You see, I will not refer to any political outfit, but I will say the glorious role played by lawyers. Our Constitution, about which we are so proud, and which is one of the best documents in the world. This Constitution, which governs the largest democratic country in the world, created by lawyers who fought for this Constitution. If we look at the history behind the Constitution, because in every country, every Constitution evolves out of national struggle. Look at the British Constitution, though it is unwritten, but it evolved out of several social struggles like the Glorious Revolution, the Petition of Right, the Magna Carta, and all these things, and the evolution of common law. It's an amalgam of all the concepts arising out of this. The American Constitution is the result of the American War of Independence. The French Constitution arose out of the great cry, fraternity, dignity and equality, fraternity, liberty and equality of French Revolution. Even as recently as the 1970s, the Bangladesh Constitution also evolved out of the national struggle for their language. A country is born out of the struggle for establishing their language. Unique thing in the history of the world. But it's all born out of national struggle. In our case, in the national struggle, one of the first major agenda was for Swaraj. What is Swaraj? Right of self-determination, right of a people to govern themselves on the basis of laws formed, written by them. So first you remember that this Constitution was not given to you by the state which is governing the country. This Constitution evolved out of people's suffering, people's toil, people's struggle. The rights which you are getting today, first of the most important right of free speech, as our opening speaker said, liberty of thought, liberty of expression, liberty of belief, liberty of faith, liberty of worship. Look at the subtraction of liberty. Justice, political, economic, and civil and social of the widest dimension. There is one thing which is not very much talked about, but it's value in the Constitution. Dignity of the individual and fraternity. This divisive politics of today is completely opposed to the Constitution. Fraternity. We must have a fraternal feeling. Fraternity is a value in the Constitution, in the preamble. dignity of the individual and the fraternity amongst all citizens, among all people. So these values evolved after a lot of struggle. And ultimately, the British, those who came to rule us, they had to withdraw, they had to accept these values. The whole world accepts these values. Now, what are the pillars of our constitution? I consider there are three pillars: democracy, secularism, and socialism. They are all united. You cannot take one from the other. If you make one of them weak, the other has to fall. It is a socialist democratic republic, meaning thereby that every individual's voice would count. The right of dissent, the right to speak one's mind freely is our birthright, is our human right. Nobody can take it away. I'll further explain. Nobody can take it away. State cannot take it away. Because these are your fundamental rights, and how fundamental rights have been protected in the Constitution? There is an article which is not very much read by persons, but that is also a fundamental right. Article 13. What is the purport of Article 13? Article 13 has two parts. First part, it says that all the existing laws, pre-constitution laws, suppose I'll give you an example of Indian Penal Code, Indian Contract Act, Indian Evidence Act. These are all pre-constitution laws. They shall continue, but on one condition. They must conform to and be compatible with Part 3 rights, that is fundamental rights. If they infringe to the extent of inconsistency with fundamental right, that law will be declared void. Who can declare such a law void? Judiciary. And it has been declared. You know, some of the parts, some of the provisions of the Indian Penal Code have been declared void. 377. There is another section, I think 494 or something, been declared void by courts. Because this is no longer consistent with the evolving mosaic of fundamental right. And what is fundamental right? It is evolving, it is not static. See, I'll give you an example. Right to know is not there in the Constitution. We have a right to speak. But what has the Constitution said? The judges said that I cannot speak properly unless I know. This is basic. Unless I know the facts, I cannot speak. So right to know is a facet of the right of speech. It's equally fundamental. Therefore, we have the Right to Information Act. Say, for instance, in the matter of making the roots of democracy stronger, what the Supreme Court has done. You know that previously, say prior to 1990, when a candidate is up for election, seeking your vote, you did not know his financial details nor the criminal antecedents. You didn't know that. You have to make a choice blindly. Suppose I am a candidate. Maybe I am having huge black money. I am having lots of criminal cases pending against me. But I was under no obligation to disclose. But the Supreme Court said it, made it very clear in 2 judgments in the 1990s. Well, how could the Supreme Court do it? By giving an expansive interpretation of fundamental right. Previously it was said that your right to cast vote is not a fundamental right. Supreme Court said yes, it is. How? Said that when a candidate is seeking my vote and a voter is giving his vote in favor of the candidate, the voter is making an express, a conscious choice. My right to choose is part of my right of expression. Whether I'll vote for him or I'll vote for you. This is how I express my democratic rights. It's part of my right of expression. The right of expression has been given a very wide meaning. Because when I cannot effectively exercise my right of expression unless I know your details. Therefore, Supreme Court directed the Election Commission to make such a law. When that law was made, that was again challenged, Supreme Court again affirmed it. That is how the democratic fabric of the country is being strengthened by Supreme Court. I will give you one example. When the first communist government was elected in this country in 1957 in Kerala, headed by EMS Ramudripa, but that government was overruled and dismissed by governor and replaced by governor's rule. Nothing could be done. But today, if that had been done, it could have been challenged, and I'm sure, more than sure, it would have been set aside by the Supreme Court. But the Supreme Court has evolved this concept of judicial review. Previously it was said that when governor gives a recommendation and on that basis the president passes an order of overruling an elected government, that is beyond judicial review. But in Mumbai's case, the very famous case, Supreme Court said, no, court can examine it and court can overrule it if the court finds there are not sufficient reasons. And in that judgment, Mumbai's judgment, Supreme Court has given a very, very important declaration that not only secularism is a basic feature of the Constitution, that was said in Keshavananda Bharati, but that secularism is the soul of the Constitution. It is the soul of the Constitution. This should be known by everybody. But I tell you, Supreme Court has also spoken in discordant voices. Somebody was talking of Hindu Rashtra. Now, after independence, Manohar Lal Joshi, this is all on record of Supreme Court judgment, gave a call in an election meeting that give me vote, I will raise the first Hindu Rashtra in India, that is Maharashtra. I'll create it. He won the election. His election was challenged. Bombay High Court set aside that election. Then he went to Supreme Court. Supreme Court upheld it. And do you know by what logic? By what logic? Do you know by what logic? The judges of the Supreme Court held It is reprehensible to give such a call.
ਹਾਂਜੀ
But it is not a corrupt practice. How funny. How can you call it? That is, if it is what is meant by reprehensible in common English parlance, is something which is bad, which cannot be tolerated. You see, it's not a corrupt practice. It is reprehensible, no doubt. It is against the Constitution. If it is not a corrupt practice, which one is? The upheld is election. It is the same judge, same learned judge, who in a 5-judge bench, in Ismail Faruqi's case, you remember that case? This is not the present Ajanta dispute case, previous one, where the masjid was demolished and the government acquired the land. Matter went to Supreme Court to outlaw the acquisition because it's a religious place. You can't acquire it. Out of 5 judges, 2 judges. This is Amidi, this is Barucha, said yes, it can't be acquired. And the majority judgment, again, illogic will laugh. So it can be acquired because they said, the learned judges said, offering namaz in a mosque is not an essential tenet of Islam. Yes, I'm quoting Supreme Court. I'm quoting Supreme Court. But that is how. But at the same time, Supreme Court has spoken in favor of common man's right also. When the pavement dwellers of Maharashtra approached Supreme Court through a journalist, Olga Tellis, the Maharashtra municipality was saying that we must remove them, want to beautify the city, must develop the city. Said you can't remove them without giving them alternative accommodation. It is from the pavement they make their livelihood. You can't evict them without giving them an alternative place. But what is happening today? Bulldozer politics. I have requested the Hon'ble Supreme Court by letter, myself, some other learned judges were there, to initiate a proceeding, and proceeding was initiated, the bulldozing has been to some extent stopped. You must fight for your right. I think I have overshot the time. If I go on, I can go on for the whole day. But you see, these are the values. These are the values, these values will remain. These are everlasting values. These are values of civilization, values of humanity, which are enshrined in our Constitution. Our Constitution was given to us by lawyers. Our freedom, in freedom fight, the lawyers were at the forefront. Now tell me, which country can boast of its first president is a lawyer? We can. First Prime Minister is a lawyer, we can. The first Home Minister is a lawyer, we can. And the father of the nation is a lawyer. So before I conclude, my brother judge was talking of the preamble. Before preamble, it was drafted as objective resolution. And that drafting, Pandit Nehru took the major role and he gave a small speech. He said that when the Constitution of New France initially was being drafted, the monarchy of that state did not give those draftsmen even a place to sit, even a room to sit, to draft it. What they did, they drafted their resolution for framing a constitution in the tennis court, sitting in a tennis court. That is known as the tennis court resolution. Let us be all enthused by that spirit, that enthusiasm, that vision while drafting the preamble. And if you read the preamble, you'll find the same vision transparently looking at you, asking you to take steps. So the last battle which you have to fight is to transform Constitution into reality. And that can be done by you. You lawyers, I'm looking forward to you. And I'm very happy and very privileged to be able to give this inaugural speech in the second National Convention of All India Lawyers Council. Thank you.